All right, I'm going to go ahead and get us started so that I can get out of the way of the panel. My name is Michael Hunter Schwartz, and I'm the Dean of the Law School. And really, all I have to do today is to share thank yous. First of all, I want to start by thanking, and I don't actually see where he sat down, but start with Mike Belote. Where are you, Mike? There he is. So we believe, Mike, that this is our 6th annual Belote lecture. We had a little bit of gap during the pandemic, and so we're really excited. I happen to be the president of the Mike Belote fan club, and so we're gathered together here at the podium. But I do need to say that Mike is consistently ranked among the top 100 in California politics in our state. He won just a couple years ago the Outstanding Philanthropist of the Year. He had the excellent good wisdom to attend both UC Berkeley and McGeorge. And most of all, he's just been a great person. In my time since I've been dean, if he counted them, he would have the unfortunate problem of having received probably more text messages than any other McGeorge alum from me. And so with apologies and thanks, it says something about him that he is the kind of person that we just are constantly in touch. So I also want to thank Murphy Austin, who is our partner and a sponsor of tonight's event. I want to thank the planning committee, the faculty, staff, who've been working so hard on all the things related to our 100th anniversary. If you could join me in applauding them for all their hard work. This is our 8th event of our 100th anniversary festivities. And you think we just started in January, that's a pretty good number. I also want to generally thank the McGeorge students. There's a good number of you here, so if you could applaud yourselves. I know them well enough to know that, yes, they don't mind good free food and free booze, but I think they are here for the education, and I so appreciate them showing up for everything. I want to thank my moderator, my friend, the Associate Dean of the Law School, Mary-Beth Moylan, for her excellence in everything she does and her willingness to work harder than any normal human can or should. And finally, I want to thank, I want to thank our panelists. Thank you all for being here. And I finally want to thank and turn things over to Erin O'Neill. She's now been over our Capitol Center for 3 years, 4 years? Something like that. And for those of you, there's a lot of members of our Capitol board here tonight, and they would confirm that since she has taken over the Capitol Center, it has just soared. And so she took something that was great, and I think she's made it even greater. And so please join me in thanking and celebrating Erin.
Thank you, Dean Schwartz, and thank you so much to everyone for being here tonight. We're so excited to have you here with us. As Dean Schwartz mentioned, this is our 6th annual Mike Belote Capitol Center Lecture Series. I'm Erin O'Neill. I'm director of the Capitol Center for Law and Policy here at McGeorge, and our Capitol Lawyering Concentration, which is a program of study for students who are interested in jobs at the intersection of law and public policy. And we are absolutely thrilled to welcome our panel tonight. As Dean Schwartz mentioned, this is our 100th anniversary of McGeorge here in Sacramento, and we wanted to do something really special for this year. And we looked around and thought about it. We always try to highlight a very timely policy topic with this lecture series, and nothing is bigger or more news-making this year than the presidential election in 2024. So we have a fantastic group of panelists, starting with Noah Bookbinder, who is CEO and president of CREW, Citizens for Responsibility and Ethics in Washington, the organization that spearheaded the Colorado litigation with other states joining as plaintiffs with regard to former President Trump's place on the ballot or not, depending on how you interpret the 14th Amendment. We have Professor Justin Levitt, who is a visiting professor at UCLA Law, a resident professor at LMU Law School, and served as a policy advisor to the Biden administration regarding voting rights and election law. We have Jasleen Singh, who is Democracy Counsel at the Brennan Center for Justice, affiliated with NYU, a policy think tank that looks at issues of governance and election law. And finally, our own Associate Dean, Mary-Beth Moylan, will be the moderator for this evening. So I am going to step out of the way and let the panel do their thing. But again, thank you all for being here, and thank you, Mike Belote, for being the sponsor of this event.
Thank you, Professor O'Neill and Dean Hunter-Schwartz. I am so excited about the conversation that we are going to get to have with this esteemed panel. Our preparatory conversations have been really interesting, and so I am confident that we are going to have some interesting conversations tonight. So the overarching question is about the fact that we have a delicate democracy that is fraught with division and disinformation, and how are we going to ensure that we have fair elections, that we have safe, reliable, and elections that will allow us to encourage participation and also ensure that we have qualified candidates that are being elected. So maybe another way to say it is, are we going to make it through the 2024 presidential election with our democracy intact? Fortunately, we have experts here in fair elections, in election litigation, and in ballot access. And while all three of them are national experts, they also all have a tie to California. So we're going to try tonight to cover mostly national issues and to talk about what's going on nationally. But we're hoping that in the question and answer period, we can get to some of the more California-specific concerns. To start, I'm going to ask each of the panelists to just briefly describe a project or a case that they've been working on, and then we'll springboard from there. So first, I'd like to ask you, Jasleen, if you could talk about your work with the Brennan Center, and specifically about projects you're working on to combat threats to democracy.
Sure. Good evening, everyone, and I'm really excited to be here and to be part of this conversation. I actually want to provide a little bit of an overview of what the Brennan Center does to sort of highlight the multifaceted way in which we're answering that question of, are we going to be okay? And I think the answer is certainly yes, with obvious caveats. So we, the Brennan Center, are part think tank, part law firm, part communications hub. And we really do take a multifaceted approach to protecting democracy and justice. And so we engage in advocacy work, so policy advocacy. We're talking to state legislatures and federal legislatures, trying to pass legislation that expands the right to vote and protects voting access. We litigate, so we get involved in cases either as plaintiffs or as amicus, telling the court why we think, or challenging vote suppression laws, for example, or getting involved in redistricting. We also have a team at the Brennan Center dedicated to elections and government work. So what that means is we're talking to elections officials on the ground doing the work, trying to shore up the security issues that could be real threats in our elections. These are the folks who are working with poll workers, trying to assess what are the threats that you're facing. And there have been a lot in the last 4 years especially. They've been facing harassment, intimidation, and so we have a team of folks figuring out how do we protect you as a poll worker, as an election official, from what's going on, from what backlash you're sort of experiencing as part of your job. And then we have a research team, so we have a growing arm at the Brennan Center of social scientists who are supporting our advocacy work through research. How do we be the best advocates we can? Let's get numbers. Let's look at this. Let's look at this through that lens. Let's get the data. And so, for example, we recently published a report on the racial turnout gap. So in 2020, we saw the highest voter turnout we've seen in over a century, but the racial turnout gap between white and non-white voters had increased significantly since the 2012 election, and that has only increased since, and it continues to increase. So we have a report that actually backs that claim up with numbers and a close look at the data that we have on turnout across jurisdictions. And then, of course, we are a communications hub. And so we advocate in the public court, essentially. And so partnering with media outlets to get our research out there and to sort of educate the public about what's going on. And so I mention all this sort of just to say the way that we approach our advocacy is multi-pronged, because that is sort of the creative diversity needed to engage with this project of protecting democracy. And we certainly do this not alone. We are a national level organization, but we work with so many allies, and I think this project of protecting democracy would also just not be possible with the intense grassroots work that organizations on the ground do as well. So I think you need both, and I just wanted to give a flavor of what the Brennan Center does sort of at the national level. Thank you.
Thank you. That was really helpful. Justin, could you please talk about your work as a senior policy advisor to the White House on democracy and voting rights, and what strategies are being put in place by the executive branch to ensure that we get fair elections this year?
Sure. And I'll start, before I do that, just by thanking everyone again as well. Not only my colleagues on the panel, but everybody affiliated with McGeorge, who's made this such a wonderful event. So thank you very much for the invitation. I've had the privilege to wear a number of hats in the election space. I've served as voter protection counsel for national campaigns. I've worked at nonprofits like the Brennan Center. I've served in the Civil Rights Division of the DOJ. And my latest escapade, my latest permission from the dean to go do something else in the real world, was to go serve as the first ever senior policy advisor for democracy and voting rights at the White House. I was both unquestionably the best person to have ever served in that role and also the worst person to have ever served in that role. So I carry that with me. And the thing that strikes me the most about that, I think, is how different that role was from actually most of the exceedingly important pieces of the election puzzle that you heard from Jasleen. The executive branch doesn't have a very significant role in federal elections, and certainly doesn't have a very significant role short-term, year to year. And of the executive branch authorities, the White House has perhaps the least significant role year to year. There are very important authorities that CISA and DHS has with maintaining the security of the election apparatus. There are very important authorities the DOJ may have with litigating particular election laws or in setting up observers to make sure that the election proceeds as it should. But the White House really, for a lot of very significant design reasons, can't, shouldn't, doesn't flip a switch and change the way elections are held at all. And so the vast majority of my work was leaving behind many of the, it's not that the Brennan Center's work is short-term, they have a lot of long-term figures in the pie as well, but all of the short-term work that the Brennan Center does do is incredibly important, and I had to set virtually all of it aside to serve in the White House. We worked on budget. Among the most important things that we did was make space for the biggest commitment to funding elections at the local level ever. $10 billion over 10 years and another $5 billion over 10 years to the post office to make sure that we can actually maintain the infrastructure of infrastructure even as we're maintaining the infrastructure. People don't recognize that elections actually need funding until they go wrong. And we haven't been funding our elections to the extent they deserve for a very long time now, 20 years since our last sort of recognition that apocalyptic elections can happen. And it's our responsibility to actually step up to that. The president proposed the most ambitious budget in 22 years. I proposed the most ambitious budget ever and the first sustained funding in 22 years. And Congress essentially ignored it. The president cannot make policy on his or her own. We also worked on legislative policy, as did nonprofits, including election administration legislative policy, including a reauthorization of the Voting Rights Act, restoring the Voting Rights Act to where it should be, came very, very close but there too did not get over the congressional bar. We did, I'll come back to this in just a second, manage to reform the Electoral Count Act, which was a really significant piece of legislation buried in a Christmas 2022 Holiday Appropriations Act. So if you missed Division P of the Omnibus Consolidated Appropriations Act, I don't blame you, but it actually managed to help secure portions of the post-election process, which we're going to talk about, I think, quite a bit. That was part of my work in the executive branch. And then mostly it was work on the other social determinants of democracy. We're used now to thinking about social determinants of health, that it's not just genetics, it's not just diet, it's not just the medical care that you receive, but a lot of other social determinants that have an impact on your health care, where you work, what your stress levels are, what your family situation is, environmental justice. Those things all affect health. Turns out that in addition to the extremely important work on campaign finance and election administration and redistricting, none of which I am slighting in the least, just like diet and genetics and exercise and medical care are extremely important to healthcare, so too are there social determinants of democracy that are important to all the rest of the stuff. The information environment, the census, the ability that we have to foster social connections and the extent to which people are feeling isolated or alone, volunteerism. All of those things build healthy democracy or detract from healthy democracy. And those are things where the executive branch has a little bit more room to foster policy that help build up the democratic substrate. I said I'll come back because this is in a way a transition to what I'm sure Noah will talk about. The one piece of legislation that was really notable that we did get passed was this revision to the Electoral Count Act. And it helped remove some of the problems that we saw in 2020, some of the long time lingering uncertainties about how the count should go. It helped, I think, streamline the path from the day we vote to the day we officially confirm who the president-elect is and prepare for inauguration. But it also left some uncertainty, and I know that's the gap that I'm sure Noah is going to step into in a moment. So I'll cede for now, but I'm sure we'll talk about a lot of the rest of that later on.
It feels like a real cliffhanger, but we'll all hold on. Okay. Noah, can you talk to us about the work that Crew is doing? And I think people would probably specifically also like to hear about the Colorado case and your role in it. And I'll let you go.
Thanks a lot. Thanks also, for having me here. It's great to be part of such a distinguished panel talking about such an important issue, and appreciate you all coming out to join the conversation. So Crew is an organization that's been around for 20 years now. We work to reduce the influence of money in politics, to promote ethics in government, and increasingly in a way that I really couldn't imagine when I came to Crew in 2015, we work to try to ensure that democracy in the United States continues, that's preserved, and really going back to the question that Mary-Beth started this conversation with, which is both a laugh line and also a really serious matter is, do we necessarily have a democracy after this November? And I share ultimately Jasleen's optimism that we will and we do, but we need to be taking this really seriously. And we were, as everyone else was, we were in a place after the 2020 election where we saw this thing happen that certainly had not happened in any of our lifetimes, which was that a sitting president who lost an election tried to keep himself in power anyway, and using various legal and then extra-legal tactics, and ultimately inciting a violent insurrection. And as we think about the many ways to try to protect democracy in the wake of an attack on it that we really have no reason to think can't happen again and won't happen again in the near future. One of there are a lot of ways, and my colleagues here have already talked about some of them, but one of the ways of addressing that is by looking at the fact that this isn't the first time this has happened. And actually, there were, the framers of the post-Civil War amendments to the constitutions had thought of this already. In the Civil War, you had an attack on the Republic, you had an attack on the rights guaranteed in the Constitution, and the framers of the 14th Amendment drafted this section that was actually not incidental. It was a very central part of the debate and the discussion when the 14th Amendment was ratified, but one that was largely forgotten in the 150 plus years since, which said that if you are someone who swears an oath to support the Constitution and then you engage in insurrection against the Constitution, you're disqualified from office. And the idea is that if you are somebody who tried to overturn our constitutional system once, you could do it again, and you don't get to be put in that position again. And our lawyers and a lot of thinkers outside of Crew looked at that and said, hey, maybe this is actually something that could apply to this situation we find ourselves in, and maybe it's a way to protect the Republic from the folks who just attacked this constitutional system, up to and including the former president. And so we set out to find a way to turn those sort of forgotten words into reality. And in 2022, we represented a set of New Mexico residents who brought suit to remove from office a county commissioner in New Mexico who had been an organizer and participant in the January 6th insurrection, and were successful. Court did remove him from office. The Supreme Court just a couple weeks ago denied cert in his appeal there. We may circle back to that because it's actually, I think, pretty important. And then in 2023, we, along with a really amazing bipartisan team of outside attorneys, represented Republican and unaffiliated voters in Colorado, suing to block Donald Trump from the ballot as disqualified under the 14th Amendment. Ultimately, we won in the Colorado Supreme Court. And then, as you probably know, we did not win in the U.S. Supreme Court. There are a few things to say about that, and I think, I'll talk a little bit now, and then I think we may have some more discussion on this. One of the things I concluded, I think, from that really strange opinion that came out of the U.S. Supreme Court is that ultimately, they didn't want to do it. They didn't want to remove Donald Trump from the ballot, and so they found a reason not to. It's not a reason that makes a whole lot of sense in terms of the language of the Constitution or the history of the 14th Amendment, but they came up with something. They abandoned, the majority of the court sort of abandoned their commitment to originalism in the process. One of the things we've seen over the past couple of years is kind of institution after institution in the United States refusing to take steps to hold Donald Trump and the others who tried to keep him in power after losing an election, refusing to hold them accountable, refusing to acknowledge that this is an ongoing threat to the democracy. And the Supreme Court joined that list. So that was the bad news. But the good news, which is what we think, one of the things that we think was really important in that decision, is that the Supreme Court was invited by Donald Trump to exonerate him. And they did not. They very pointedly, if you read the three opinions in that case, the Trump versus Anderson case, there's not a sentence in there that suggests that Donald Trump didn't do it, that he is not disqualified, that he didn't engage in insurrection. They've sort of found a loophole and they let him out on that loophole. And in fact, every decision maker that has substantively examined the issue has found that Trump engaged in insurrection. That includes two courts in Colorado, Court in Illinois, the Secretary of State in Maine, partially at least the court in New Mexico. And that remains true after the Supreme Court decision. And a lot of, we'll talk, I think, more about some of the other many projects that Crew is involved in on the legislative front, on the research front, on the communications front, legally. But one of the big things we're doing is getting the word out about what really happened in this case, that there was this sort of, the initial coverage is, Trump won. But in a lot of ways, Trump didn't win. Trump has been found to have engaged in insurrection. Nobody has found otherwise. It's now, important for all of us to kind of find ways to protect the democracy going forward. So let me stop there. There's a lot more to be said about that.
Yeah, there sure is. So I guess I do want to follow up, and this is just for anyone. Maybe we take a few minutes right now to kind of see where are we then with respect to disqualification. What does the New Mexico case mean that they denied cert? How is that helpful? If you could maybe just expand a little bit on what are the options at this point. Is disqualification as a route to ensuring that we don't have insurrectionists out the window, or what are the steps, right?
So I'll start there, and happy to hear from my colleagues about that as well. So there are a couple of things that were really significant about this New Mexico case and the fact that the Supreme Court denied cert. Couey Griffin was a county commissioner in Otero County, New Mexico. He is the founder of a group called Cowboys for Trump. He participated in a bus tour recruiting people for January 6th. He was on the steps of the Capitol with a bullhorn. He was not personally violent, which matters. And as with the Trump case, there was a trial, there were witnesses, there was a whole process. He was found to have engaged in insurrection, and he was disqualified. In his case, he was actually, his stuff was removed from his office, and the door was locked, and he lost his government position. And the Supreme Court chose not to take that case up. And that tells us, I think, two central things. One is that as seemed to be the case in the Trump versus Anderson opinion, but there are a lot of questions that opinion left open, this is another indication that door of disqualification is still open for states to disqualify state officials. That the sort of loophole that the court used to take Donald Trump off of the table was saying that states don't have the power, absent legislation from Congress, to disqualify federal officials. But it now seems pretty clear that state officials are fair game. And as we have, and I think we're going to see more of this over the next number of years, people who participated in that effort to keep Donald Trump in power after losing an election, running for office, in some cases running for office after being convicted of crimes, and in the cases of those who had previously sworn an oath to support the Constitution, prior office holders, prior members of the military, disqualification is very much a tool that can be used. So that matters. And the second thing that really matters about that opinion is that this was another chance for the Supreme Court, in a more backdoor, sort of low-key way, to exonerate Donald Trump. In other words, they could have taken up this case and quietly found, actually, January 6th is not an insurrection for the purpose of the Constitution. They could have found that you needed to personally engage in violence, a lot of ways that could have had the effect of saying Donald Trump is not an insurrectionist. They didn't do that. So this was two chances in a few weeks for them to come out and give Donald Trump a pass, and they didn't do that. That really matters. So where does that leave us? It leaves us, that we have this avenue potentially for people to bring suit in the states when it comes to state officials. The Supreme Court has made clear that Congress can legislate to allow for a state or federal process. I actually think that is something that could happen in the not too distant future. I think it's probably a long shot this year. We have a situation where legislating in a way that could affect Donald Trump is partisan in a way that it should not be. But we're sure as heck going to try. We're working with members of Congress on legislation that would be generally applicable. It's not just for Donald Trump. It's for anybody who engages in this kind of conduct. It should pass. I think at some point it will, but it's going to be a project. There are other questions. If somebody like Donald Trump is elected, could Congress refuse to certify that election? It's a complicated question for a lot of reasons. I'm not sure that the decision in Trump versus Anderson gave a lot of clarity on that question, so that's still out there. But the other piece of this is continuing public education, making sure the American people understand what happened, what courts have found, and that's going to be what they should ask Congress to do. That's a big part of this going forward as well.
You want to add, Justin?
Yeah, if I can, just a few things. So part of Trump versus Anderson, and part of what I think we should take from Trump versus Anderson, is that the Supreme Court does not do its best work in a hurry. Bush versus Gore was delivered in a hurry, and there are a lot of questions about some of the logic and some of the conclusions and how far they run outside of those particular circumstances. And Trump versus Anderson was delivered in order to make sure that the opinion came out before the final day of voting in Colorado, before Election Day in Colorado, although ballots had still gone out absentee. That meant it was delivered in a hurry, and it's not the court's finest work. Enterprising reporters have found that from the metadata that there were some glitches in the headings that indicate that something that might have been a dissent turned into a concurrence, and some of the language feuding back and forth might well have been different had they had another couple weeks to change their minds. One of the questions that it left is the question that Noah raises: do you need legislation? The court kind of said maybe yes for federal office holders, and then it also kind of said maybe no, and all of that is dicta, because there was no federal process here at all. So big question mark there. More big question marks, they didn't actually answer the question that was raised to them. The question that was raised to them had nothing to do with enforcing the 14th Amendment. It had to do with protecting Colorado's citizens from voting for a person who would not later be eligible to hold office. And the court decided, yeah, but that's not the question everybody wants to know about, so we're just going to jump to that question instead. That also left a little bit of jarring discontinuity with some of the questions that were actually raised below. There are a lot of different issues that I think are still pending after Trump v. Anderson, even though Noah's absolutely right. The one thing on which it remained most tangibly silent is, did he do it or didn't he do it with respect to the former president? One tiny thing to add for Couey Griffin, I think before January 6th, there were, I think I've got this timeline right, he'd refused to certify an election in Otero County,
Actually,
New
it
Mexico.
was
It was after
January
6th.
6th.
Sorry.
Yeah.
It's another reason to believe that he was of an insurrectionist mind, because there was no dispute about the validity of the ballots in Otero County. He was one of the county commissioners responsible for certifying the election, like adding up a final tally and pressing equal, and then saying, yes, we see that this number is bigger than that number. That's the only job. And because of vague, unarticulated, unexplained, indefensible notions of potential fraud maybe somewhere kinda, evidence-free, he refused to certify the election. I think actually in a federal election, that's a federal crime under the Voting Rights Act. And I think it's equally important to recognize that all of the reasons that Noah presents for the validity of the third section of the 14th Amendment also are related not just to January 6th, but to a lot of election processes and a lot of our democratic processes far beyond. That's part of why it exists. Two other really small things on the import of Trump versus Anderson for accountability and what do we do now. So I actually do think that Congress still has the potential to deem Donald Trump disqualified. I think he's good for it. But beyond that, I think that a process finding that even outside of legislation is still viable under Trump v. Anderson. The Electoral Count Reform Act is ambiguous on this, as in a lot of other things still. I think it leaves room, certainly some senators think that it leaves room to not count ballots cast for Donald Trump because of this 14th Amendment question. I don't think, and I want to be really clear about this, that there is any realistic possibility that that will happen if he actually legitimately wins a majority of the Electoral College. That voice, the people's voice in speaking to this issue, is going to make the conditions politically impossible for a majority of Congress to remove him from the ballot, essentially, or deem him disqualified after an election in which he has won the Electoral College. So I am not suggesting that Congress will exercise this power, but I think they still technically have it. What's more intriguing for me is whether they've already done it. So more than half of the House and more than half of the Senate have already said as a factual matter that Donald Trump committed an insurrection, engaged in insurrection, and that he is disqualified to serve. They just did it in the context of a proceeding that needed a 2/3 vote. The second impeachment. A majority of the House voted, and more than 50 senators voted, and found this as a factual matter. And at least for a law professor, I have the luxury of thinking weird thoughts about things. That circumstance doesn't happen in any other context. You don't know how most of the jury would have voted in a different case than the case you have. The voting rules that we have most of the time preclude getting an interim factual finding on an issue without also taking that to its legal resolution. And by the peculiarity of the impeachment procedure and the fact that it's done in an open vote, we actually know more than half of Congress thinks that he is affirmatively disqualified. It's just that that didn't lead to the next final check mark. And that is, I agree, something that the American people will ultimately be the deciders on. All of our jobs, in a way, have to do with engineering a plane and building a plane and making sure the plane is fueled and making sure that it flies and making sure the doors stay on. But the American people get to pilot it where they want. And they're going to be able to decide the ultimate direction that plane goes in this fall. And the fact that Congress has had these findings and the fact of these facts that don't go away, those can and should be really relevant.
Yeah, interesting. I'm just sitting here thinking procedurally, how does this, how do we bring that up other than just through good old-fashioned voting? Jasleen, did you want to add anything on this?
Yeah.
Okay, let's pivot at this point a little bit. I think, Justin, you also wanted to talk about the Electoral Count Act, and maybe you could explain a little bit what actually got done and what was left ambiguous, and how that has the potential for impacting what happens in the post-election period.
So I'll try to make this short. It exists in a page, and I will try to do my best to make it exist in a paragraph. The Electoral Count Act is an 1880s law that Congress passed to set up the process by which we decide, once the Electoral College votes, how Congress counts those votes in the event of a controversy. It was set up by the controversy of 1876. That was a giant mess. Congress said, we're not going to have that mess again. So they wrote a statute in 1887 that was almost designed to make sure we had that mess again at some point, because the statute is incomprehensible and also internally inconsistent. It sat, and lots of commentators weighed in on the fact that it was both incomprehensible and internally inconsistent, and it sat, and it sat, and it sat. And ultimately, some provisions of that law, including the provision that seemed to indicate, I say seemed, didn't actually, but seemed to indicate that there was some latitude for states to decide how their electors' votes would be cast even after Election Day under certain circumstances, led to, I think, a feeling among the electorate when Donald Trump lost the actual election. So you're saying I got a chance. And that, so you're saying there's a chance, built and swelled with frivolous litigation over the months to come in what amounted to what became January 6th. And for most of the people who heard repeatedly, the election system is rigged and unfair, the election system is rigged and unfair, it's very understandable why they would take to other violent means when they're repeatedly told that you have no agency in deciding who the government is through the regular process. That was wrong. That was an abundant fiction. But the continuing promotion of the big lie directly fed an outpouring of citizen frustration, I think, at this process that they were repeatedly told was unfair and couldn't possibly have been fairly won. The Electoral Count Act in some ways not fed that, but it permitted that by offering this tantalizing hope of, so you're saying there's a chance. One of the things that the Electoral Count Reform Act did was a very bipartisan, emphatically bipartisan effort, tucked in an Appropriations Act, so it's not possible to see the exact vote count that would have been held on it, but I can promise you there was bipartisan support for it well before it was tucked into the Appropriations Act. It removes any notion that you get to change the rules after Election Day. It tries to make the process of certifying an election clearer, more certain, so that there's only one electoral certificate delivered to Congress, and so that there are means to make sure that there's only one certificate delivered to Congress, so that when Congress confronts an electoral certificate, there's no question, is this the right one or the fake one? Because there'll only be a right one. And it gets the judiciary involved a little bit in channeling those fights. What it doesn't do, unfortunately, because legislation is compromise, it doesn't resolve ultimately the, so you're saying there's a chance. Unfortunately. Congress preserved for itself a role in deciding whether particular electoral certificates would be valid or not. The threshold in the Electoral Count Act got raised, which is great. So you won't see a renegade member of Congress stalling the entire proceedings. But you could well see a renegade group of members of Congress stalling the proceedings, and ultimately Congress has still left itself authority to decide the validity of electoral certificates that everybody else recognizes as valid. And I worry that that latitude will still amount to a, so you're saying there's a chance. And I don't think it is merely a Trump or merely a Biden, so you're saying there's a chance. I think there'll be pressure actually from contingents on either side of the aisle to have their representatives or their senators vote to invalidate electoral slates depending on how the election actually comes out. And that, I think, is a very real missed opportunity that's an unfortunate remaining ambiguity in the statute, by design. This time it's not incomprehensible drafting, this time it's because they wanted it there.
Interesting, thank you. So we have all sorts of other lawsuits that we could be talking about, and yet here we are running out of time and focused on only one lawsuit and one piece of legislation. I do, though, want to make sure we have time to also talk about some of the other concerns that we are seeing in this election, including voter suppression, including the harassment of poll workers that Jasleen was talking about. And so let's pivot to that for a minute, and hopefully some of you will ask some questions about some of the other pieces of litigation and legislation.
Sure. So I'll take the litigation question first. So we have been seeing some litigation that's sort of laying the groundwork to call into question the 2024 election already. And so a series of suits have been passed since January, some in March, in several states across the country. And they're alleging basically the same thing, that the state's voter rolls are inaccurate, they're riddled with errors, there's ineligible voters on the rolls, and there's deceased voters on the rolls, some version of that. And what this is doing, one, and having taken a close look at just a couple of them, the methodology they're using to come to these conclusions are shaky at best. This tactic has been used before. It was used in 2020. It was used in 2021. But what it does is it sows doubt in the integrity of elections, right? And so it's laying the groundwork to say, in 2024, if the election doesn't come out the way these plaintiffs would have liked, well, your voter rolls were inaccurate to begin with, and now the election itself is called into question. And so it's sort of an adaptation and revival of what we saw post-election in 2020, but it's starting now. And I would say, I think like what we're looking out for this year is tactics that feel very like nationally focused, taking place in states across the country. And so like our organization is thinking deeply about how do we make sure we're prepared and how do we respond to things like this? Because they are indeed frivolous lawsuits at the end of the day. So that's a sort of flavor of what's going on with litigation outside of that. There's ongoing litigation against restrictive voting laws that have been passed in the last few years. There's ongoing litigation with redistricting that hasn't been resolved and likely won't be resolved, unfortunately, before the 2024 election. But on the topic of restrictive voting laws, so something to keep in mind about this election, and the Brennan Center has been looking at voting legislation that's been introduced and passed across the country in all 50 states for the last decade or so. We saw a massive proliferation of restrictive laws, even expansive laws, just voting legislation generally. There was a flurry after the 2020 election of legislators on both sides of the aisle sort of taking cues from 2020 and going in one of two directions. And so we saw an unprecedented number of restrictive laws passed, also expansive laws, which is great, and also is part of what gives me hope about, yes, we'll be okay. But voters in 27 states are going to be facing new barriers to voting that they didn't have in 2024. So that's something that we're thinking about, and you know, and yeah, that's going to be a hurdle for people in certain states. And I think increasingly how easy it is to vote is sort of dependent on how you live. So here in California, we get our ballots mailed to us, and we get a lot of information just mailed to us about how to vote, when to send things in, if you can't, if, you know. And other states, one, you have to be eligible under very narrow circumstances to even request a mail ballot. You have to request it every single election. Sometimes you can do it annually. And so those are the sorts of things that that unfortunately has become a divergent force in the country, is just who. Certain states are passing restrictive laws, certain states are going the opposite direction, and actually saw that unprecedented turnout in 2020 and were like, you know, what were the things that we put in place for this election that encouraged people to come out, and how do we make that more permanent? And then I can't remember the last thing.
Well, just about poll workers and the threats to poll workers, which I think, you know, the New York Times just had an article about the suits for defamation. Again, I think it was just a couple days ago, and I think that seems to be, you know, in order to have a nice democracy, we have to have people who are willing to work at the polls. And if people who work at the polls and work in elections departments are being threatened and harassed and defamed, people aren't going to want to participate.
And that's been absolutely true. And we've done surveys with election officials over the last couple of years, and there is extremely high rates of turnover occurring at election offices across the country. At a trial that we were part of last fall, there was a Texas county election official who said that she had been trailed with a poll watcher with a firearm, basically to her home. And so these are very, very real threats. I think some of the work that Brennan Center is doing is education work about the laws that do protect poll workers and that are in place, both for poll workers and for voters. So, for example, federal law protects against voter intimidation, and every single state has some version of voter protection laws against intimidation. Some states have also taken that extra step and made it explicit that those sorts of laws also apply to poll workers because it's become such an issue since 2020.
Can I just add 30
Yeah.
seconds?
Yeah.
So mostly because we're at a law school event or law school sponsored event, what Jasleen has pointed out about the national trend is absolutely right, and the fact that people who are volunteering their time should be facing harassment at all for one of the most salutary small d democratic processes there is a shame, is a national shame. But it's also very locality specific, and there are lots and lots and lots and lots and lots and lots of places that are not seeing those sorts of pressure, those sorts of attacks, and of relevance here. So I'm very proud to be at a law school that has closed down classes every 2 years on general election November in order to encourage students to serve as poll workers. We have a partnership with Los Angeles County, we have a partnership with Orange County, we're down in Southern California, because there is no better way for law students to learn what it means to be a government official than to serve as poll worker. There are 3 ways that we get to be government officials as private citizens. We get to vote on ballot initiatives, right? We're legislators for a day. My wife hates it, but we are. She blames me whenever she has to vote on something. She's like, I pay people to do that. Why do you make me vote? I didn't do it. We get to serve on juries, and we get to serve as poll workers. And those are the only 3 ways that we get to be government officials for a day. And that poll worker service, there is no better way to apply laws and regulations to facts on the ground repeatedly throughout the course of a day than serving as a poll worker. And the students regularly love it because, of course, it's wonderful small d democratic service. So this is by way of saying the attacks are there, but they're not everywhere. And where there is a culture and a community around poll worker service, I cannot emphasize enough how wonderful an experience it is. If you haven't had the opportunity, go do it. And if you know the opportunity exists for others in your orbit, encourage them to do it too. It's the most democracy reaffirming activity I can think of.
I love that, and I am a poll worker, and I think it goes back to what you were talking about earlier, the social determinants of democracy, right? Like this is a kind of full circle right there because we need community, we need people to go out and have faith in the system so that we have a system to have faith in. Okay, I have a million more questions, but we have a room full of interested and engaged people here, and so I want to turn the questioning now over to my very good friend, Dorothy Landsberg, who had her hand up first. So she gets the first question.
What a terrific panel. So Justin,
Take the mic, Dorothy. There you go. Okay.
So Justin, I worked in the Civil Rights Division in 1965 to 1967 and was involved in the initial implementation of the Voting Rights Act under John Doerr. My question really is, after Shelby County, which because it declared Section 4 unconstitutional and therefore Section 5 inoperable, which required pre-clearance, and other decisions that have occurred both in federal and state court, and because of what the Brennan Center found out, which does not surprise me at all, that the racial disparity in, that the voting disparity has increased, racially has increased from 2000. And so the question is the Civil Rights Division, the Lawyers Committee, the Brennan Center, all the wonderful nonprofit and governmental entities, are they up to the task of really protecting against racial discrimination?
Yes and no. They can't possibly be, and yet they are doing just tremendously important work trying to run upstream, as fast as they possibly can in as many places as they can. The genius of the original Voting Rights Act is it recognized that you can turn inertia from the side of the wrongdoer to the side of the victim in making sure that in places that had the most serious histories of discrimination, where a majority of the population in a system of majority rule could not participate, did not participate, that those places had to get permission before changing the rules to make sure they didn't make it worse, right? Very, in my view, tailored to the problem. And it was the only way to stop the game of endless whack-a-mole that was jurisdictions deciding to change their rules one by one by one by one, as you know extremely well, in order to fight an abundance of incentive by local office holders to discriminate because they were playing with house money, right? If you happen to lose a lawsuit, then just change the rules and force the plaintiffs to bring a new lawsuit, which takes time and money, and all of that is working in your favor. You get to socialize all the burdens and privatize the costs on the plaintiffs. And so the Voting Rights Act changed all this. Shelby County is the one case I cannot teach. I can teach a lot of cases. I can teach Citizens United just fine. I can teach Bush versus Gore just fine. I cannot teach Shelby County because there's no law there. It's just power. And I don't find it useful to teach students that sometimes just power is the answer, because that doesn't help them in any other further case. From a lot of cases, you can draw rules and say in the next case you can do X or Y. In Shelby County, I just said 5 people disagree with you, so you lose. That's it. That's part of why it's heartbreaking. You can't take it seriously. They weren't looking for a reason to uphold what Congress had done. They were looking for a reason to strike it down. Much as Noah says, they were looking for reason to avoid the ultimate question in Trump versus Anderson. So I am not going to be the one defending Shelby County. It had a lot of enormous impacts. It is part of the reason why it's so essential to restore and revitalize the Voting Rights Act that Congress can do whenever it wants, and every, as you know, reauthorization of the Voting Rights Act has been vigorously bipartisan, including 2006, in an environment that did not otherwise speak to a great deal of bipartisanship. And it needs to, and it must. And the president has not been shy in calling on Congress, and we very nearly got there, but didn't in 2022. A giant personal disappointment. Congress can still and should still, and in the meantime, it takes an immense amount of time and energy and talent and expertise, and nonprofits like the Brennan Center and LDF and a lot of others in the Lawyers Committee and the Civil Rights Division are working as hard as they can. But the structural rivers they're running upstream into are difficult to hold back with individual barriers, with individual swimmers. I've now mixed all of the metaphors there are. They're doing what they can, but it's not enough. And we need them to keep doing whatever they can until we get a structural change in new legislation to make sure it's enough.
Well, and I think to follow up also on what Jasleen had said before, right, we're seeing all of these more restrictive laws that have come about, just to be clear, as a result of Shelby County and as a result of the no longer having preclearance. So I think that just to connect dots for some of the students. Yeah.
20 seconds more connection, and I promise this will only be 20 seconds. There's a longer term possibility that this will change, that you'll start to see different collections of states deciding that their restrictive laws aren't worth their while. And that's because I think the states that are restricting the franchise are working on conventional wisdom, and the conventional wisdom has changed, or should change, needs to change. Donald Trump has been extremely successful at bringing infrequent voters into the bastion, into the arms of the Republican Party, right? Part of his unquestioned success is mobilizing infrequent voters in 2016 and 2020, and is going to do it again. And the laws that are restrictive, that increase barriers to the franchise, hurt infrequent voters first and most.
Interesting.
And I think very shortly people will start to realize that their conventional wisdom that it may be Democratic voters who are burdened by some of these restrictive laws is not going to be so unilaterally true anymore. And that may change the incentives to have some of these laws in place. I don't know that we're going to get there before November, but we may get there short after.
Interesting. Other questions? Yes, Elizabeth, and then, oh, Alec has already got the mic. Elizabeth, you can be after Alec. Sorry, go ahead, Alec.
Hello. Justin, you had said something earlier about when people were told the big lie, that they felt like they lacked agency. And I know kind of on the flip side, a lot of people feel like they lack agency for the presidential election because of the Electoral College. If you're a Republican in California, your vote doesn't matter for president. Vice versa, Democrat in Wyoming doesn't really matter. So with that, there's the National Popular Vote Interstate Pact, and was just curious if any three of you could touch on whether, if any of you advocate for that in states or against it, and if it were to pass, would there be any conflict with Congress potentially not certifying the results, because then it's no longer based on the electoral vote, or how that would interplay if it were to pass?
Anyway, I'm happy to answer. I don't know whether either one of you want to or can't.
I mean, I will defer on the last part of the question. I will certainly say, we are supportive of sort of reconsideration of the Electoral College, which comes from a time and a set of considerations which I think no longer apply to modern America. And I will just I'll just say here that I think something that sort of needs to be said in part of this conversation is that which I think sort of unifies the voter suppression laws we see in a lot of states. It unifies the threats that are posed at election workers, threats at high-level election officials. I was just reading yesterday about this sort of unprecedented rise in threats against the Secretary of State in Colorado, who is the chief election official in that state. It goes to the sort of threats that are aimed at those who bring legal action to try to bring about accountability. These are not things that are happening because there is a vague mood in the country. These are things that are deliberate, that are done to try to change the outcome of an election, to make it easier for somebody who lost an election to win another election, to end up in power in some ways regardless of how people vote. And so I think that that's where you get, I think, the relationship between these sort of structural reforms, which we desperately need, but also accountability. That these are not things that are happening in the abstract by some amorphous force. These are actions that are being taken by specific people to undermine democracy. And I think there's a real connection there. I went way outside of the question. So on the question of the Electoral College and whether a pact is legal and constitutional, I defer to you both.
Anything on this one? So I will not take long on this because there are lots of really complicated questions around legalities and practicalities, including with the new Electoral Count Reform Act, and ways that it doesn't contemplate the national popular vote. So I'll punt a little bit on the question, although I'm happy to engage it afterward, because I got a lot of feels on this particular issue. The one thing I'll say is that sitting in Sacramento, if you're feeling a lack of agency about the presidency, there are so many other races to vote on, always, everywhere. And so I think we nationally spend way too much mental energy around one individual. We are attracted to stars and lone figures and cowboys, and that we, at our own disservice, neglect all of the other offices that change our lives in so many other ways. There is always someone to vote on where your vote matters. Even if you feel like, and I'm telling you it still matters for president, but even if you feel like it doesn't for president, you got a whole long ballot to consider beyond that. So.
And we need to always, we've been talking about so many things that Congress has not been able to do, right? And California does matter for Congress, for the Senate, like Congress mostly, not. Anyway, okay, so it does matter, and that's good. I'm going to let Elizabeth have the last question, and then we are going to wrap up this conversation that could go on for, I think, 2 or 3 hours if we let it, but we're not going to. Yes, Elizabeth.
Thank you, and thank you all for a great conversation as well. I have a two-part question, and I hope it makes sense. So right now we're seeing a lot of movement across the country regarding voting uncommitted or voting ceasefire, things like that. And so I'm curious to know how you see that affecting our democracy. And my second question is, I know a lot of people that are not voting or are leaving or like not trusting our democracy. And so what are you currently doing? What is your work doing to ensure that we're bringing those people in and engaging in our democracy?
Thank you. I think that's you, Jasleen.
Yeah.
So I think I'll answer the second question first, but and it's something that Mary-Beth said earlier. Our democracy is really only as strong as we think it is. And so I think so much of the harm that has happened since 2020 is it's hurting ourselves, you know? Like, yes, we want to be critical of our institutions. Yes, we want to hold them accountable, but we've gone past that sort of threshold, and we have and so many people have questioned the integrity of our elections, of the people who make elections run, of the procedures that make elections run. America's been holding elections for forever, right? And election officials have been doing their jobs for a really long time. They know what they're doing. And so I think that the hope that I have is that we actually try to entrust those people, those procedures, those tried and true mechanisms of elections. And I think the work that that my organization has to do is to tell the public, like, hey, these are the protections we have in place. It'll be okay. And I think about the 2020 election. That election took place during an unprecedented global pandemic. Election officials rose to the occasion. Our own DHS called that election smooth and secure by and large, right? And so even in like the worst potentially election that we've experienced, at least in my lifetime, and I'm sure our lifetimes, we still succeeded, and those election officials still succeeded, and our election procedures still succeeded. And so I think that is something that gives sort of me some hope that we're gonna be okay, because we have these institutions, and despite the threats that are coming in from so like various aspects, we still have these institutions, and I encourage us all to sort of have confidence that our institutions will come through. I think to the other question that you had about voting uncommitted, that's a personal choice for a voter, and I think what Justin was saying is there's so much more than just the presidential election, and so if you don't find someone that you jive with in that presidential election, there's a lot more that may even impact you on a day-to-day that happens at the local level. And so I would encourage folks to not vote, because ultimately, and you know what Mary-Beth was saying, like, you still have a lot of power to get folks elected into positions that can have an impact. Maybe it won't be next year, but it's gonna be 5 years down the line, 10 years down the line.
Great. Please join me in thanking our outstanding panelists. And please also join me once again in thanking Mike Belote for making this lecture series possible.